Did you know that ending Citizens United today wouldn't actually end corporate personhood? You heard that right. There is a different actual Supreme Court case that actually positions corporate personhood before Citizens United, which is 2010. This argument was put forward by this idiot over here, Roscoe Conkling, which was the senator from New York at that time. He was there during the drafting of the 14th Amendment, and as such, before it was actually ratified, he published an article that implied that when the commission that was drafting the 14th Amendment was deciding on the language to use, they specifically chose person over citizen to include corporations. Now, this was his own reshaping of reality in order to actually position what he would eventually go on to do during this case. See, it was the likes of former U.S. Senator Roscoe Conkling to thank for the extension of equal protection to corporations. Conkling helped draft the 14th Amendment. He then left the Senate to become a lawyer. So he went to the Senate first, he helped draft the 14th Amendment, then he became a lawyer. He argued to the Supreme Court in San Mateo County versus Southern Pacific Railroad that the 14th Amendment is not limited to natural persons. Because he published a journal some years before the 14th Amendment, he positioned that meant that the writers, the drafters, intended for the 14th Amendment to include corporations. This is not necessarily constitutionality, but it is what's called originalism, which is the intentions of the writers when they were writing it. This itself is incompatible with constitutionality because Article 6 Supremacy Clause assures that the Constitution is the law of the land, not the opinions of the drafters of our social contract. However, the courts were literally like, I trust you, bro. And then they positioned, the court does not wish to hear arguments on the question whether the provision in the 14th Amendment to the Constitution, which forbids a state to deny to any person within its jurisdiction the equal protection of the laws, applies to these corporations. We are of the opinion that it does. So they didn't even question Conkling's intentions. They just said, I trust you, bro, because you were there. What this means is that even when Citizens United is overturned, we still have this precedent. Precedent and law literally just means a decision that has already been established and can be used in reasoning in order to decide future legislation. It's kind of like an example that, but the problem with precedent is that it can easily be repealed, such as Roe versus Wade. Versus Wade was precedent. However, it was overturned because all you need is a different, much more conservative, much more extremist government in order for those political rights to be threatened, to be in danger. What's required in those instances is codification within the Constitution. So what this tells us is that even if Citizens United is overturned, we still have to deal with the precedent of Santa Clara County versus Southern Pacific Railroad, which already established corporate personhood. To fight this, what's required is a constitutional amendment that is invoking Article 5, which is the Amendment Clause. Why? Article 6 of the Supremacy Clause asserts that the Constitution is the law of the land. This means that the Constitution can't change U.S. law. U.S. law cannot change the Constitution. Only the Constitution can change the Constitution. So in order to safeguard that corporate personhood is not included within that can be capable of deciding political future, which means that corporations and special interests are capable of outbidding the people. We need codification, how you say, because Congress isn't going to agree to pass such a progressive policy, right? For an example, because I know it seems really unrealistic for there to be an amendment clause to repeal something that we perceive that Congress would be incapable or unwilling of doing. This was how they felt when it came to prohibition, which was the 18th Amendment, which established a nationwide ban on the manufacture, sale, and transportation of alcohol. It was repealed with Amendment 21 in 1933. The 21st Amendment, which is that which repealed the prohibition, is the only constitutional amendment to date to repeal a previous amendment and also the only one to have been ratified by states ratifying conventions rather than state legislatures. This method was chosen so that average citizens would weigh in on this sensitive issue without political pressure. This means that instead of having the state legislators deciding on approving the 21st Amendment, what happened was that the states selected delegates. These are kind of like the electoral college kind of delegates. So these people are much more capable of aligning with what the people want versus that of special interest, because it is not Congress who is deciding on whether or not we want this amendment. It is the delegates. Now, how does this work? Congress started considering a draft of the 21st Amendment that would repeal the 18th. The House and Senate passed it in February 1933 and sent it to the states for final approval. Under the amendment, each state had to vote on the issue by referendum, and if repeal won the popular vote, the state's legislator had to appoint and send delegates to state conventions where delegates would vote up, down on repeal. The purpose of the requirement was political, to prevent the Anti-Saloon League and lobby and dry legislators from bottling up the amendment in the state legislators. So they chose to get delegates versus the state legislators because they knew that the special interests advocating for prohibition would have much more power, which would have much more financial capital than the average people. So they chose to send delegates versus that of congressional action. And this is the method that will work when it comes to removing the Electoral College, when it comes to removing corporate personhood, because it's not just about overturning Citizens United, it's about removing corporate personhood from being a person. Amendment would have to clarify. Article 5 has to be invoked in order to clarify through an amendment that the only people are those which are individuals. It is you and me. It is people who are born. It is people who are like us. It is not a collective. People are the ones who make the collective. It is not the collective who make up people. We have to clarify this through an amendment. It has to be clarified because you know who gets a death penalty? Me and you can get the death penalty. A company doesn't get the death penalty. Who was prosecuted for the 2008 recession or all the risky business deals? No one. Maybe a few, but I'm not going to say it's going to be a substantial amount of punishment to where they learn their lesson. Because if we're just going to do it through legislation, as in a legislation that overturns Citizens United, then we have this that corporate personhood is still a legal principle. It's still a legal precedent. Then without codification, you have to prove that Conkling was wrong. It's already been a really long time, and he was in the space when they were drafting it. So how are we going to prove that he was wrong? How are we going to prove that he did it for his own personal ambitions? The fact that he said that they meant persons as to include corporations. You have to prove that this was not the intention of those who drafted it. And even then, personally, we shouldn't even be interpreting the Constitution based on originalism, because if you really want to do it based on the writers and what they intended, then obviously women wouldn't be considered as persons. They wouldn't be equals. Black Americans wouldn't be equals. No other contract is interpreted through what the writers actually wanted. You have to read it, and if you don't like it, you say something, you fix it, but if it's not within the margins, it doesn't count. Sure, if we had an independent court where possible of actually going through those nuances and seeing which attorney is capable of actually having the much substantial argument, but in this reality of our court, it's not going to happen, an independent judgment. We require an amendment in order to eliminate corporate personhood. Is the only sustainable long-term solution to actually recentering the people versus that of special interests and corporations and in the benefits of the U.S. government. To keep that temptation of special interests, of corporate money, then obviously no matter how much integrity politicians has, everyone has a price. So if we continue this, then we're just simply going to be in the same familiar misery. The solution is at the constitutional level of Article 5. Anything less, we're just going to continue in the same misery, because at the core, corporate personhood was placed by someone who knew what he was doing. He knew that he wanted to advance his own profits, and as such, precedent was based on self-ambition versus that of actual legal reasoning. And as such, we require a constitutional amendment.